Good afternoon, everybody. My name is Katie Ensweiler. I'm the marketing manager at VonLehman CPA and Advisory Firm. Just a few housekeeping items. If you can, please keep yourself on mute so we can eliminate some feedback noise. Also, if you have any questions for our panelists, please enter them into the chat feature within Zoom. We will get those addressed for you as the presentation goes on. Huge thank you to our partners on this event, HORAN and Graydon. We couldn't have done it without you. Thanks for all the planning and work you did to put into today. And with that, I will go ahead and turn it over to Beth. But just so everybody knows, in the event that you do need to get off the call early, we are recording it and we'll be sending it out after today. Thank you very much. And Beth, I'll turn it over to you.
All right, thanks, Katie. Good afternoon, everyone. Thank you so much for joining us. I want to echo what Katie said. Thank you so much to HORAN and Graydon. Both are always such amazing partners to work with on any event, so we really appreciate it. I just wanted to take a couple of minutes to just remind everyone that we are really looking to do these kind of events on a regular basis throughout 21. So just be on the lookout for more invitations. We did an event on cybersecurity for retirement plans back in December. So if you were not able to attend that, Katie is going to send out the video link for that presentation as well, as it was recorded. I think we all know that cyber continues to be a very hot topic in all aspects of our lives, and it is certainly hitting retirement plans as well. So we wanted to make sure everybody was in the loop on the latest and greatest regarding that. So thank you again for coming, and I'm going to turn it over to our moderator, Carrie. Carrie, take it away.
Thanks, Beth. Good afternoon, everyone, and thank you all for joining the call today. My name is Carrie Walls. I'm a manager at VonLehman. I joined VonLehman in 2013, and I specialize in employee benefit plan auditing. I'm going to serve as the moderator today for the panel. I'm going to now ask each of the panelists to introduce themselves. Beth, so I'm going to hand it back over to you.
I guess I could have done that before, huh? So good afternoon again. I'm Beth Vice with VonLehman & Company. I am a shareholder in our audit department. I have been with the firm, I think 22 years now, a very long time. I literally started as a teenager and have never left. So one of the areas that I focus on is employee benefit plan auditing. The firm does quite a number of retirement plan audits every year. So I certainly don't claim to know everything, but we've certainly learned a lot along the way and just the different audits that we do and working with different plan sponsors. So I'm excited to talk about some of the things that we see in those audits. Thank you, Carrie.
John, would you like to go next?
Sure. Hi, everybody. My name is John Kirk. I am an attorney with Graydon. I've been practicing exclusively employee benefits and executive comp for the last 20 years. My practice is, everything retirement plan related, including ERISA litigation for when things, we'll say, go south. Health plans, all those sorts of things. If it has ERISA or benefits in it, it's sort of what we do here at Graydon. Started my career at the U.S. Department of Labor. So I was the guy knocking on your door, coming to audit you or investigate you, we'll say. And since then, I've been at firms and I've been in-house for a large insurance broker. So I've seen lots of things on both sides of the wall. So, lots of knowledge to answer your questions.
Paul, would you like to go next?
I sure would. Thank you, Carrie. So I am Paul Carl. I'm the man with no last name. I'm a 35-year industry veteran, and much like John, I was an adversary for a little while. First 8 years of my career with U.S. Department of Labor. The last 27 years helping a variety of size employers with their retirement plan. At HORAN, I'm a retirement plan consultant, fiduciary plan design advisor, and one of a team of 6. So, and I'm happy to be here. Thank you.
Okay, thanks for the introductions, everyone. Now we'll get started with some questions. The first question I have is for John. John, do we need a retirement plan committee? And if so, who should be on it?
Well, that's I think that's when we'll probably touch on all three of our expertise, but I would say, yeah, you do need some sort of committee, because if you have a retirement plan, you are very likely a fiduciary. You may be the named fiduciary, which means your name is actually in the document saying you're the fiduciary of the plan, or you're what's called a functional fiduciary. You may not be, your name's not there, but you do everything for the plan. You make all the decisions, you're making the investment decisions, you're doing all those sorts of things, which means you still have all that liability. So I always recommend a committee, even if it's just 3 people, it's better than you relying on your own wits. It's always better to have other people to bounce ideas off of, other people who have more expertise, more knowledge, different life experiences to help with those decisions. It's sort of selfishly for you, it sort of also spreads the risk around a little bit in that there are now other people making decisions besides yourself. But the other benefit is you have somebody to talk to. And so a lot of times in the litigation world, if you are sued for an issue in your retirement plan, so a bad investment, someone claims a bad investment decision or a bad decision somehow, the Department of Labor is looking at, did you act reasonably and prudent in making those decisions? And so if you can say, oh yeah, I discussed it with these other people at the company and we looked at all the angles and kicked the tires,
thank you.
and we ended up there, then that's going to go a lot better for you than if you just said, yeah, I'm the only person, they asked me, I just sort of did what I thought was right. So that's a very long lawyer answer to say, yeah, I really think you should have a committee. And I always like odd numbers, so 3, 5, 7. I think you get much beyond 5 or 7 and it gets way too cumbersome. 3 to 5 is a good number to sort of have on that committee.
Thank you, John. The next question I have is for Paul. Paul, I meet with my current advisor quarterly. We review investments and I get an economic update. Is this sufficient to fulfill my fiduciary responsibilities?
Well, so the short answer to that is it is important to review the investments. Now, how frequently they're reviewed is really up to ideally that committee that John just talked about and your advisor. Certainly no more often than quarterly. Quite a few, may find quarterly to be too frequent, especially as advisors have taken on co-fiduciary and fiduciary roles. They're monitoring, deeply monitoring the investments behind the scenes. So the frequency, certainly annually, if not semi-annually, if not quarterly. But in addition to those, there's other responsibilities that the advisors can, or services that the advisors can bring. And one of which is with regard to the investment policy statement, cash equivalent option, the QDIA. Those meetings should include an independent evaluation of those at least once a year. Don't overlook that. Don't overlook the fiduciary training that you should probably go through. Ideally, one of those meetings, if it's quarterly, at least one of those meetings includes some fiduciary training. Make sure everything's documented and make sure that there's an evaluation taking place of all your service providers, record keepers, TPAs, and that should be a part of the meeting as well. So it's great to have investments, absolutely necessary, but there's some other features that should be included in those meetings.
Thank you, Paul. Beth, what advice would you give a plan sponsor that has reached the level where they will need an audit of the retirement plan for the very first time?
Great question. Most people don't get too excited about this, of course, when they have achieved that level where they need an audit. I will say, I just encourage everyone not to panic. Myself and people in my shoes that are CPAs that do these types of audits are much nicer than Paul and John when they worked for the Department of Labor. If you've got the Department of Labor coming to knock, you might want to panic a little bit more. I know I've always heard Paul say that if you get that letter from the Department of Labor, it is not an audit, it is an investigation. So I always keep that in the back of my mind, what Paul taught me. But For an actual audit from a CPA firm, the first thing that I would tell you is to review your census data. Make sure that you really have, in fact, crossed that threshold. Oftentimes, we will see that there are errors on the census, and maybe you haven't actually hit that level yet where you need an audit. So I would just double check that information and make sure that everything on there is accurate when it comes to that employee count. Finally, next, make sure you talk to your service providers, your TPA and such. They're going to help you through this, and they're going to provide a lot of the information. So you're not going to be doing this all on your own. Make sure that you sit down with the auditor and really walk through all the things they're asking for. They're going to give you a list. It's going to have all kinds of things on it. It's probably going to look pretty daunting when you first look at it. It's going to ask for a lot of employee records, a lot of payroll records, plan documents, census, all those kind of things. So just sit down with your auditor and really go through each one of those to understand what they're truly asking for. Keep in mind too, in this remote world, if you do start transferring things, back and forth with the auditor, just keep in mind the security behind that and make sure that you are transferring those in a secure way. A lot of this information is going to have, very private information, payroll, social security numbers, try to make sure that it's just the 4 digits, not all the digits. But for instance, with the pandemic, pretty much every benefit plan audit we did last year was done remotely. So, there was a lot of information being transferred back and forth between us via, some type of secure platform. Another thing that I think people often forget about is when you've never been audited before, we have to go back to prior years as well. That's really up to an auditor's judgment as to what they have to do and how far back they have to go. But just be prepared that your auditor is probably going to ask for some information even from years before the actual year under audit. So again, don't panic. It's not horrible to have to go through one of these audits, because I think most plan sponsors really do learn a lot, and they really get to know their plan a lot better when they really have to dig in and pull all of these things together.
And let me follow up on what Beth said. This is John. On the legal side, we're starting to see more investigations from the Department of Labor of audits. So when you're thinking about hiring an auditor, when your committee gets together and say we need a service provider for your audit, look for somebody that specializes in these audits, like Beth and her team, because the OCA, the Office of Chief Accountant, did an investigation. They found about 1/3 of plan audits that they're getting had issues. And if they find the audit had an issue, it means you, the employer, the plan sponsor, didn't timely file your 5500, and you can have penalties from that. So step one, find the people that have that expertise in that audit, so you don't have to worry about that should you get the DOL investigation letter later, because it's, oh, sorry, your auditor's messed up.
Yeah, that's a great point, John. Even, as auditors, we get audited by the Department of Labor. They will randomly choose audits that we have completed to look at. Luckily all of ours have, we've never had anything come back from the Department of Labor, which is obviously great news. They're pretty picky, and, they will look through everything that we do. But, we're on the hook too, because, they have the ability to pull a CPA firm's ability to even do benefit plan audits. So John, that's a great point that, when you are looking for an auditor, you really want to look for someone with that expertise, just to keep everyone in line when it comes to this.
Hey Beth, so what's the number that triggers the audit? How many participants trigger that audit for the first time?
Yeah, so the number you'll always hear is 100, obviously, but there's really a special rule in place that you really have to get over 120 participants to trigger that first time audit. I think the important thing for everyone to really keep in mind, though, is the definition of a participant gets a little confusing. That's why I mentioned really go back and look at that census. So a participant can obviously be somebody that's, participating in the plan. That's pretty easy. But it could also be someone that has, terminated, but still has funds in the plan. It can be someone that is eligible to participate in the plan, but isn't actually putting anything into the plan. And that's where most people get tripped up, because you could have several employees that are eligible to participate in the plan under the rules of your plan document, but have chosen not to for whatever reason. But they still count as a participant when you're working towards that 120. So again, just really keep in mind that the definition of a participant can be very tricky, and to really work closely with your payroll company, your TPA, whoever you're working with, to make sure that that census is accurate.
Thank you all. Actually, to kind of go off that, John, do you really need a lawyer if you are audited by the DOL or IRS regarding a 401k or any kind of retirement plan?
I like to think, yes, you always need a lawyer. But, it depends on how experienced and how knowledgeable I think you are with your plan, and how much the committee is with the plan. So if you feel like, if you get that first letter from the Department of Labor that says, they've opened an investigation of you, it's a long list. It's kind of scary. I mean, it runs multiple pages, has numerous subparts. There's a lot of info they want, and sometimes for multiple years. So what, at least with a lot of my clients, we may get involved to sort of help, we'll say, translate what they're asking for, and say, here's what you need. Here's how you should respond. Here's maybe how you organize it. Because truthfully, when I was at the DOL, and Paul can probably back this up, I used to just dump a banker's box full of documents, and then we'd have to sort through them. Well, that puts the DOL person in not the best frame of mind. We want to keep them happy. We want them to sort of have a positive relationship with you, even though it's adversarial. So, nice binders with things labeled, those sorts of things are some things, if a client's never gone through that will help with. A lot of times, we'll be involved sort of on the front end, helping organize and figure out what's there. And then we may not be involved for quite a while, because if it goes relatively smoothly and they don't find a whole lot, there's not a lot for us to do. So if you got a pretty good handle on it, I'd say, feel free to respond if you think you can do it and you understand what they're asking for. It's when they start coming back with multiple requests, and at that point, they're really starting to maybe zero in on some issues they've found. That's a lot of times where the attorneys get more involved, because the first round, they're sort of just looking at everything, and then they may ask about something else, and then all of a sudden they're asking some very, very specific questions about certain things in the plan and certain ways you did things with the plan. And that's a lot of times where it may be best to bring the lawyers in. You'd still be involved in it, but then we can sort of help you navigate on how to craft those responses, because based on our experience, we sort of generally know what they're going after. And it could be you've done nothing wrong, but they think you have, and we can help explain that. Or it could be, yeah, you've got a couple issues, and now's the time to maybe bring in attorney-client privilege as we work on some of those things, to prepare to respond to that and potentially defend it if we need to. So again, I always think you need one, but you really start needing one if they start asking those specific questions or getting more into the details. That's when they may think they've hooked the fish, and you may need somebody to help defend you.
Thanks, John.
I'll just add to that, as a best practice, notify all your providers. If you have an advisor, notify your advisor. Make sure your record keeper, your TPA, your auditor, and especially the attorney, because if the Department of Labor thinks it has legs, as John said, you're definitely going to want your attorney involved. But keep all your providers apprised of that situation.
Absolutely, because truthfully, you're going to need all your providers, because the documents they're asking for, you don't have all of them. Paul's team has some of them. Beth's team has some of them. Your record keeper has some of them. You're going to have to talk to everybody you deal with to respond to that audit. And so it's almost impossible not to let them know. And if you try to do it yourself, you're going to make mistakes, and it's just going to go south quickly.
Thank you. Paul, the next question I have is for you. I read that total financial wellness is an important part of the retirement plan. In fact, our record keepers keep us updated on new and improved tools for employees with their finances. What's my responsibility to make sure that my employees are in good financial position? I mean, I'm not in charge of their spending habits and I don't want to be.
Wow, that's a really loaded question. Thanks for that. I appreciate it. So, first of all, I'm going to make the assumption that the person asking this is the primary plan fiduciary, be it an individual or the committee that, John's already referenced that we've talked about. So the duty and the role there is to make sure, now I'm assuming that this is participant directed plan, make sure that education is available. You want to make sure that education is available, and you want to make sure that the participants are aware that the education is available and how to go about getting it. So however that messaging is communicated is really, it falls on you. But at the end of the day, it's really about, hey, we're here to educate you and make you aware of, what the plan offers, how to save for retirement, how to create that successful path to retirement. And the interesting part is this total financial wellness that's in the question. That's a new focus. In the past, it's been, here's what the plan is. Here's how you save for retirement. In an ideal world, this is what you'll accumulate and you'll have to retire on. Financial wellness, as the 401k, 403b, independent participant directed plans really have matured, especially where we've seen it is with individuals in decision-making capacities, and they're kind of noticing some colleagues of their own age maybe aren't as successful financially. They're saying we need more financial tools, and the record keepers, the advisors, we're bringing those tools and helping people create budgets and better understand their finances so that they can have that total financial fitness or wellness program.
Thank you, Paul. Beth, can you tell us what are some examples of controls plan sponsors should consider having in place as it relates to a retirement plan?
Yeah, sure. That's a great question, Carrie. For those of you that, work in the accounting and finance world, you hear about internal controls all the time. So just what are some of those policies and procedures that you should have in place, regarding your accounting functions that are going to keep you in check and help make sure that bad things don't happen. You really need to have that same mindset on the retirement plan. So it's just as important to have good controls in place when it comes to your retirement plan. So some of the things that, we talk to people about, especially in this, electronic age, what are your policies and procedures internally when it comes to approving distributions or loans? A lot of things all happen online now. But, as we, have heard about and with our series in December on cybersecurity, people are trying to get into accounts and take fake distributions and fake loans. So what kind of procedures do you have in place so that you can help combat that when that would happen? I think another important piece is for plan sponsors to always talk with their service providers, their TPAs, their record keepers, their custodians, to see what kind of controls those entities have in place to help combat some of these things. One thing that you can request is their SOC report, their service organization controls report. Now, not everyone is going to have this, but many providers in this world do. And this is a good report to get just to get an idea of what controls they have in place on their end. And not only that, but there is often testing that's done within these reports, and you can take a look at how they did. How did how did Fidelity do on these different tests that their independent auditor did in regards to their controls, or Schwab, or fill in the blank. So I would definitely recommend everyone request those reports each year from their service providers and take a look at those as part of their internal control structure. Another area to concentrate on is to make sure you have some type of procedure in place with your service provider to be checking, at least each year, if not more, on people that you can force out of the plan through a distribution. Most plans have something in there. If someone is terminated and their balance is under $5,000, you can typically force a distribution to them. That kind of helps keep your plan clean, and it also drives down that participant count. So if you're kind of hovering around that level of needing an audit, you don't want to incur that expense if you don't have to. Keep an eye on that and make sure that you have a procedure in place where you're doing that on a regular basis. Another thing that, we recommend people do is just really, review the reports that you're getting from your third-party administrator, from your custodian. Tie out, contributions per those reports back to your payroll reports. Just making sure that everything that you remitted to the plan actually got in there. You can spot check and make sure that a few individual accounts got the right contributions. Just things like that you can check from time to time to make sure that things are operating as they should. Again, I would just, encourage everyone to really, take a look at what controls they do have in place. Make sure you have some good segregation of duties. That's kind of a buzz term that we hear in the financial world, but it really happens in the retirement plan world too. You don't want one person doing everything with the plan, because that can just lead to issues sometimes.
Thanks, Beth.
Hey, Beth. Hey, Beth, if there's a deficiency in that SOC report, what do you all do? How do you react?
That's a good question. So there are certain things that we do in an audit that we can use that SOC report for. We can't use it to completely do no testing on certain areas. So during an audit, we're always going to test various areas regardless of that SOC report. It was very interesting. 2 years ago, we actually had a SOC report for a pretty major custodian that did not get a clean opinion on the SOC report. A clean opinion is that's what you want. That's a good thing. They did not get that because of some issues that they had within their controls that weren't working. So in that case, we couldn't use that SOC report at all. And, that was an area where in particular, this client that was using that entity typically wouldn't get the SOC report, but we always get it as part of the audit and, would go over it with the client. And that was, kind of an eye-opening moment for them that even though the deficiencies noted in that report may not have impacted their plan in particular, it really called for them to, have a discussion with their representative at that company to say, hey, we obtained the SOC report as we are allowed to do and noticed there were some deficiencies in here. How does this affect my plan? What are you doing about this to make sure this doesn't happen again? So it can definitely have an impact on our audit, but even more so, plan sponsors need to know about those things so they can be talking to their representatives at that entity to basically reassure themselves that they're going to fix those deficiencies.
Thank you, Beth. John, the next question is for you. What are some of the most common violations you see assessed in audits?
Okay. It could be a long list, but actually that ties into what Beth was just saying. One of the most common errors we find is failure to follow plan documents. So, if you have that provision that says anyone with an account under $5,000 is cashed out when they terminate, you need to make sure you're doing that, because they will find that in an investigation and they're going to come ask, hey, we noticed you had a bunch of people that terminated 6 years ago and they never were cashed out. And your plan document says they're cashed out in this manner. So failure to actually do what the plan says is one of them. And that one comes up very frequently. The other one, and it's sort of the bread and butter of the Department of Labor, is timeliness of plan contributions for 401k plans. You know, and they're looking at the gap between when the employee was paid and when the money went into the plan. And the general Department of Labor thought process is it's at least as fast as you pay your payroll taxes. And for most of us who are using automated payroll systems, it essentially should be same day. A few days delay may be allowed. Much beyond 3, 4, 5 days in between the two, you're going to start getting asked questions and essentially be forced to pay interest and maybe penalties for that delay, because their thought is it's the employee's money. You've now, I don't say stolen it, but you've delayed it, so you've deprived them of the investment gain they could have gained on that. Now, if it's a large amount of money, that's where, you know, the law sometimes get involved and we start making arguments. Well, you know, the market was absolutely terrible, and you want to say it's a 10% interest rate. Well, they would have never made that. So we can sort of go from there into that dispute. So late contributions, failure to follow the plan document, and then sort of imprudent investments, and that's going to sort of turn on facts and circumstances. But you know, were you, the committee, acting in the best interest of the plan when you made those investments? So if we find out you invested in a company that the CEO also owns, or the CEO's brother, and it tanked, we're going to have issues. If you're in all, like if you're all in high yield international funds that in theory could do great, but in the middle of a pandemic, maybe aren't the best place to be invested, and the plan does really poorly, you could see some questions asked about that. I remember when I was at the DOL, we had a guy that invested in precious gems and South African gold coins during apartheid. So there are lots of questions asked there about the prudence of his investments. But those are probably the failure to follow plan documents and late contributions are probably the two most common we see. Those pop up in almost every audit, simply because a lot of times there's always some gap, and there's always some provision where maybe it says one thing, but in practicality you did another. No real harm to the plan except that you didn't follow it to the letter of the law. And then that's where, you know, we would suggest, well, if you do it this way, let's amend the plan language to correspond to how you do it, so we don't get in trouble in the future. But that's part of as being a good fiduciary of sort of knowing what your plan says and knowing, you know, enough about the plan operations, or being educated enough on the plan operations to know where you may have some exposure and things like that.
Thanks, John. Beth, kind of to go along with that, what compliance errors do you find in the audits that you perform? Kind of to go off with John.
Yeah, very similar to what John just said. So again, we are often the precursor that comes in and finds a lot of these things before the DOL may come in, which again is a good thing. You know, we can get you in touch with John or whoever it is to help you correct these things. So that way, if the DOL does come knocking, you know, you can show them that you corrected them. You know, the good thing about a lot of these things that we find is they can be self-corrected. You know, you can self-correct it, document what you did, and be prepared instead of having to go through some sort of voluntary disclosure program with the IRS or DOL. But it's very similar to John. The late contributions, again, I probably did my first benefit plan audit, I don't know, 16, 17 years ago. It was an issue then. And it's still, you know, probably one of the hottest issues that we see. It's, you know, sometimes it's very hard to decipher because, you know, their term about, you know, doing it as soon as administratively feasible, you know, people like to argue with us on what that really means. So it can be a very hard one to navigate, but, you know, sometimes it's very clear when something is late. You know, they did every contribution in 2 days, and then you find one that they did in 12. You know, that something happened there. What happened there to cause that? So that is certainly one that we see. We see incorrect definition of plan compensation used a lot or found a lot. And again, that is, going back to John's comment about just knowing your plan. I can't stress enough. I know those documents are hard to read and hard to understand. But, if there's something that you don't understand in those, make sure that you're talking to your attorney about it to really understand what that plan document says, because that's really going to be how you know if you are operating in accordance with what that plan says. Plan compensation can get very tricky. There could be one definition used for deferrals, a different definition used for employer contributions. So you really have to know what that plan document says. Does it say bonuses are excluded? Does it say commissions are excluded? All kinds of things. But we find that a lot, that, maybe the plan document said that bonuses are to be included, but then we come in and do our testing and realize the employer didn't withhold or match on anyone's bonus. Well, that's an issue probably. So we really do see that a lot. Auto enrollment and auto escalation of deferral percentages are, pretty hot over the last few years. So we definitely test these items during our audits. We have been seeing some instances where, people aren't following what their plan says in accordance with those. They're not auto enrolling timely. They're not auto escalating timely. So those are things to pay attention to if you have those provisions in your plan. If an employee says, I want to change my deferral percentage, not changing that timely. We run into that sometimes. We will pick a sample of, participants to test during the year. And if, John said, I want 2%, but then he changed it to 3% effective June 1st. And, us accountants are crunching the numbers and it's just not working. Well, then we find out through the payroll records that they didn't actually change it to 3% until November 1st. Okay, well, what does that mean? What does the employer owe that employee money now? There's a lot of different rules that come into play there, but those are all just compliance issues that we find. So, if you're going through an audit from a CPA firm because you've reached that level, just know they're going to look at each one of those compliance items in your plan. They're going to look at eligibility, contributions, distributions, vesting, loans, all of those things they're going to test. And if we find something, it's not the end of the world, because it really can be a good thing, because it gives you the chance to correct it at that point and not have it continue on. So again, very similar things to what John said. I would really encourage everybody just to pull out their plan document, their SPD, read through those things and make sure you know what the heck it actually means.
Yeah, and the follow up on Beth, we as attorneys, we draft plans, we create them from whole cloth, but a lot of you, use a prototype plan, a Fidelity, a Lincoln, a Prudential, whatever it might be. And those are all perfectly fine plans. But when you're going through that adoption agreement, when you're first setting up the plan, that's when you need to ask a lot of questions, because a lot of times you just get an email with a big PDF and you're supposed to go through and check those boxes. Talk to your advisors at that time about the 10 definitions of compensation they have there. Talk to it, well, how have you been doing loans, and making sure it goes over. Go through that with a fine tooth comb, and that's going to, one, educate you on the plan and its features, but also stop some of those errors up front, because you're going to know what it is. And then also that first payroll cycle after you've moved to a new provider or set up a new plan, just double check everything again, because that's a lot of times you can catch errors early for some of those. And finally, as former DO person, self-correction is fantastic. And if you self-correct, the department loves it because you fixed it. And there's no like black mark on your file if you've gone through corrections. If anything, it means you did your job, you found an error, you corrected it as soon as you found. That it generally puts us in the department in a much better frame of mind that you're paying attention to your plan. So all the self-corrections, all the sort of voluntary compliance, those are good things, because it means you've fixed it before it became a real issue.
Yeah, I can't stress.
Hey, John.
Go ahead, Paul.
No, go ahead, Beth.
I was just going to say, I really can't stress enough and reiterate what John said, especially when you first start a plan or if you move to someone else and you're going to go on their plan and you're checking all those boxes on this adoption agreement, just be very, very careful about what it says. One word, an and versus an or can completely change the landscape of things. I'll give you a good example. We had a new client that we were auditing. They had been audited before, but the prior auditor just had not caught it because, again, it was one word and it was on their employer match eligibility, and it said or instead of and they thought it said the opposite. And so they had been following that eligibility and excluding people because they thought individuals had to meet 2 requirements in order to get the match. Whereas the way that the wording actually was, it was or, and they only had to meet one of those requirements. So luckily this plan this was in 17 or 18, I believe. This plan had only been around since 13, but there were a lot of people that they excluded on accident, but they had to go back and basically fix that. And so it wasn't the end of the world. It wasn't huge dollars, but between attorney fees and our fees and just the internal, struggle of having to go through and figure out who they missed, do the calculations, do calculations on lost earnings, it was really, a tricky situation for them to have to go through over one word.
And, I'll just add to this that it's really a best practice that we've been instituted with our clients to review the plan document, review the plan provisions, especially at the time of conversion. And we'll identify the provisions, we'll highlight some alternatives that are available. I'm thinking of a plan we converted during 2020 where we prepared an analysis of the current plan document, made some suggestions, and then frankly, we organized what turned into about a 2-hour discussion with the plan sponsor, the TPA, the attorney who was one of John's colleagues, and us. And, it just made for much better understanding of how the plan is drafted, operates, key provisions. It made for a much smoother conversion from record keepers and systems. It just, a little, 2 hours sounds like a lot, but it's a small investment for maybe avoiding some pain down the road.
No, absolutely. And to Paul's point, that really should be your best practice. Anytime you're doing a new plan document, sit down, go through that with all the people who may be involved and all of the sort of your expert knowledge people. Because Paul said, those 2 hours are going to save you lots and lots of heartache later.
Great. Kind of to switch gears here, Paul, this question's for you. Our advisor and our organization just cannot get our employees to contribute to our 403B plan, and it really concerns me. I get that we're a non-for-profit and that our compensation may be a bit less, but isn't it still important for those employees to save? What can we do to encourage our employees to save and save more for retirement?
So, you know what, that's a great question. And I'll start out with this. I remember years ago, there was a bus that was running around the greater Cincinnati area in particular, and it had a billboard on it. And I don't remember which firm was advertising on it. And if I did remember, I wouldn't share it. But in any event, it said there's no do-over at retirement. So, just the fact that, one of our plan sponsor, plan fiduciaries is asking this question really tells me that they want their employees to save for retirement and create a successful path to retirement. So that's fantastic. We touched on education. Education's super important. You can never neglect education. Absolutely make sure that education's out there, make sure that employees are aware of all the tools, calculators. If you have an advisor, ensure that that advisor is delivering that education and helping with that path. But, the interesting part is statistically, it's plan design that has the greatest effect on the employee's success with retirement savings, even more so than education. We've mentioned already that auto enrollment and auto escalation, I think Beth in particular mentioned it as two items not to overlook. They are important plan design features to really encourage and help people save for retirement. What it boils down to is a plan sponsor is making a decision on whether or not to auto enroll their employees. And a lot of employers will say, well, that's not my decision to quote unquote force someone to contribute 5% or 7% of their pay to their plan. I don't want that feature. Well, that's still a decision to choose 0%. So in effect, that's a conscious decision to choose 0%. Regardless of whether you have auto enrollment or not, the employee has the ability to change that deferral amount or deferral percentage. So, to encourage people to save, quite honestly, we suggest auto enrollment. We like the auto escalation feature, especially if you've got great operational capability between the record keeper and your payroll system. And we've seen instances where a re-enrollment process, if it's clear that not enough people are deferring money, then use a re-enrollment process. Pick a date, draw a line in the sand, and anybody contributing less than 5%, for example, we are going to re-enroll at that 5% level. And if you want to opt out or go backwards or increase it, you've got the ability to do it. Most of these record keeping systems are easy to use for participants to use. They've got mobile apps as well as web access, and it can be done in most instances pretty easily, pretty handily.
Thank you. I have one last question before my final thoughts. John, do we really need to give out all the disclosures? Can't we just post them in the break room or on the internet?
I think I've had that question a few thousand times. Unfortunately, yes, you have to give them all out. Now, if everyone's got an email, a work email, you can email it to them. If there is a fairly robust online system where you can have some check the box things and things like that, you might be able to do it that way through an intranet. But you can't just post them somewhere. You can't just throw them up on a billboard or a bulletin board or lay them out in the break room, because of all the things the Department of Labor may look for in an investigation, that's low-hanging fruit. If all they have to do is a couple emails to participants or interviews with participants, did you get this? No. Or describe to us how you give out all your disclosures each year, and you say we put them on the bulletin board. That's an easy violation they can find to put in their report and sort of hang over your head. So yeah, you do have to give all those out, and it also goes back toward, as Paul said, toward the education. We know participants are not going to read most of it, but they might. And in those documents you're giving out, explains about the plan, explains about the provisions of the plan and how things work. And some people are going to read it, and you always have that one employee that reads everything, is going to ask you 1,000 questions about it. Well, at least you reached one person, but a lot of them will skim it, or they'll take it home to their spouse, and maybe they're really sort of the decision maker. So it's more useful than you think, even though I've given them out in hand in meetings and just seen the trash cans full as they all left the room. It happens, but yeah, you still have to give them out personally, to each person.
Okay, great. Thank you, John. Okay, that brings us to the end of our questions. So now I would like to get some final thoughts from our panelists. Beth, do you want to start us off?
Sure. So again, I just want to thank everyone for coming. Paul, John, and I are always available. If you just have questions, you want to bounce off of us, you need a second opinion about something, please don't hesitate to reach out. I know Katie will share our contact information. Just some final thoughts. Again, I just stress that everybody just pull out those documents, read through those, make sure you understand your plan documents so you can be in compliance. Pay attention to when you're getting close to needing an audit. Don't wait for someone, the payroll company or TPA, whoever, to come tell you that you need an audit. Oftentimes that happens a little late in the game, and then you're up against a 5,500 deadline. And the last thing you want to do is file that thing late or not file it with your audit. We have had instances of that before, and the penalties can add up very quickly on that. So just, be proactive in knowing when you're getting close to that mark. One thing I did want to point out, and John, Paul, you guys can probably know more about this than I do and can comment on it, but I think the Secure Act, if I remember right, made some changes when it comes to part-time employees that could have an impact on plans in a few years. And if I remember right, it's really related to, part-time employees and their eligibility, and that if they have 500 or more hours in 3 straight years, that can trip them into eligibility starting in 2024. But that means that 2021 is really that year that you need to start making sure your record keeping is really good behind those hours. So I'll just leave it at that. And maybe if you guys want to comment a little bit more about that, but I know that's a big deal for a lot of companies that have a lot of part-time employees, and that could certainly, trip someone into needing an audit in a few years from now. So I just wanted to touch on that. And if you guys want to mention anything, that would be great.
Paul, John, which one wants to go next?
I'll go. No, Beth's right on the 500 hours. So because of the Secure Act, now, if, as she said, if a part-time employee works at least 500 hours over 3 years, they get to be in your plan. And it's a once in, always in. So it's not like they're going to come in and out. Once they're in the plan, they're in your plan. So that means really, if you have part-time employees, you should have started tracking those employees' hours starting 2 weeks ago on the 1st, because that period of time is going to determine, can they get in, in 2024. Now, the other thing you could do is have your plan amended. If you already cover part-time employees, well, maybe you just let them in and saves you the trouble of tracking them. But it's going to create issues where you're going to have a lot more people in the plan, hopefully. So that's maybe where, as Paul said, auto enrollment and those sorts of things are maybe things you want to start thinking about later. Inertia is a hard thing to overcome. So a lot of those employees, including these new part-time employees, if they become eligible, don't, once they're in, a lot of them don't change their elections. So you helps with those contributions to your plan. But that Secure Act is going to be a big deal if for those people that have a lot of part-time employees, long time sort of part-time employees that are working consistent hours, because 500 hours isn't that many hours really in the part-time world. Sort of final thoughts for me though is, thanks everybody for coming. I think as you heard us talk multiple times, as you're thinking about your plan, as you're thinking about providers, as you're thinking about audits, make sure you are making decisions in the best interest of the plan. You're reasonable, you're acting prudence, which means you're doing for the right way in the right interest. What I like to tell clients is, because I've had this happen in litigation, imagine you have to explain your actions to a federal judge. So you're the guy sitting on the bench, sitting in the box next to the judge, and you're an employee or the department lawyers asking you, why did you do those things? How did you make that decision? Those are the sorts of, that's when we talk fiduciary duties and we talk, picking our audit service providers and our retirement plan service providers. The why is very important. And, at the end of the day, that a lot of times the government doesn't care you made the wrong decision if you took the right path to get there. So always have that, why are we doing this? Why did I do this? Why did we choose these people sort of in the back of your mind? And if you're not sure of the why, That's where, Paul, Beth, myself, your other providers, that's where we come in to sort of help you get to why I should do those things.
Thanks, John. Paul, final thoughts?
Yeah, final thoughts. So first of all, I want to thank everybody for, for making it through this. Number one. Number two, with regard to the Secure Act, I have no other thoughts other than what Beth and John have already expressed. It's going to affect those plans if you require more than 500 hours right now. So if you're already at 500 hours or less, you're meeting the requirements, but it'd be good to track it. The parting item I'd like to offer, because of at my time at the Department of Labor, and we used to manually review 5500s, I've developed a little risk analysis assessment of Form 5500s. So if anybody would like me to take a look at your 5500, I usually look at about 3 to 5 years worth, and I can identify kind of those hot buttons that the Department of Labor is looking at that's triggering potential investigations. As Beth said, they're not really audits. That's the easy term, but the investigation. So if anybody's got any interest in that, it's complimentary. We don't charge for it. So I'd be happy to take a look. Let me know.
Great. Thanks. Thank you all for speaking today. I'm going to hand it back over to Katie.
Thank you, everybody. Paul, Beth, and John, we appreciate your insights. Huge thank you to HORAN and Graydon, their marketing departments, on helping us partner with this. And to Carrie, thank you for moderating. We appreciate it. That brings us to the end of our program. We will send out the recording either later today or tomorrow, along with the contact information for all of our speakers. Thank you. Enjoy the rest of your day.